The following videos were developed as a community service in partnership between the Unified Government of Wyandotte County and Housing and Credit Counseling, Incorporated, otherwise known as HCCI of Topeka, Kansas. A series of 6 modules were developed by HCCI and Wyandotte County to address frequent issues that arise in the residential landlord-tenant relationship. The 6 module topics include rental applications, leases, non-renewals, terminations, and evictions, crime-free multi-housing advanced management techniques, rental licensing and inspection, and this current topic, fair housing as it relates to tenant screening. Information discussed in the landlord-tenant modules can be referenced in the Kansas Residential Landlord-Tenant Act, or the KRLTA, as well as fair housing laws. To learn more about HCCI and HCCI services, including landlord and tenant information, publications, and forms, or if you need to speak to a tenant landlord counselor, contact us at 800-234-0217 or 785-234-0217. You can also visit our website at www.hcci-ks.org. Introduction to Fair Housing, Screening Applicants for Tenancy. The screening process is the single most important aspect of being a landlord. Landlords have the right to screen tenant applicants and also deny anyone who does not meet their screening criteria. The key to avoiding fair housing violations is to establish routine, non-discriminatory, and objective screening criteria that applies to all. So how does this informational video involving tenant screening apply to fair housing? Well, you must comply with fair housing law in every aspect of the rental relationship. Many housing applicants experience very real housing discrimination. On the other hand, many landlords do not intentionally discriminate. They don't always understand how some actions can be discriminatory in nature and that violations could result in a fair housing complaint, or even worse, a lawsuit. This video covers many common issues which apply to screening tenants, but does not by any means cover all fair housing topics. If you have questions, you can contact HCCI for additional information. In 1968, the Civil Rights Act, also known as the Fair Housing Act, was established. The Act provides protections for the following 7 groups based on race, religion, color, national origin or ancestry, sex, referring to male or female, familial status, referring to families with children, disability, or handicap. Let us expand a little on the protections of familial status. It protects families with children under 18 years of age, to include pregnant women. It also includes any person securing legal custody of a child under the age of 18, for an example, in an adoption proceeding or tenant caring for foster children. An owner must have the same occupancy standards, or maximum number of persons per unit, applicable to all persons, whether they are adults or children. For example, if an owner accepts a married couple in a 1-bedroom unit, he must also accept a single parent and a child in a unit of that same size. While some landlords don't like renting to tenants with children, fearing the noise and wear and tear that kids might cause, the Federal Fair Housing Act prohibits discriminating on this basis. A landlord may not legally turn away or evict a tenant because he or she has children, or because an applicant or tenant is pregnant, even if the landlord has a worthy motive, such as believing that children won't be safe in the building or the neighborhood. It is illegal to deny the tenancy on that basis, or to make other discriminatory moves, such as steering families to certain parts of the property. Senior housing is exempt from the familial status portion of fair housing law and can legally exclude families with children if HUD has determined that the dwelling is specifically designed for and occupied by elderly persons under a federal, state, or local government program, or it is occupied solely by persons who are 62 years of age or older, or it houses at least one person who is 55 or older in at least 80% of the occupied units, and it adheres to a policy that demonstrates intent to house persons who are 55 or older. Landlords can't legally refuse to rent to families with children and cannot create unreasonable restrictions on the number of people that may live in a rental unit. However, local codes and ordinances can limit the number of people who can occupy a rental, typically based on square footage. Guidance from HUD provides that management needs to evaluate the size of the entire apartment or single-family dwelling when deciding about a specific occupancy standard for a unit, and that a 2+1 rule could apply. Understand there is no regulation on how many people you must allow to live in a rental unit. HUD does not mandate how a landlord should decide on occupancy, but only gives guidance. The 2+1 rule acknowledges that most dwellings are so configured that it would be reasonable for a landlord to develop a policy of 2 to a bedroom and for at least one person to use some non-bedroom space, such as a loft, den, or living room, as a sleeping area. The safest guideline, then, is probably this. If you are going to have an occupancy limit, it should be based on the number of people allowed, and it should not limit or even mention the number of children. Fair housing protections. States must recognize all 7 federally protected groups: race, color, national origin or ancestry, sex, religion, familial status, and disability. They may add more protections. Kansas protections mirror federal law and also recognize ancestry as a protected class. Communities may add additional fair housing protections, such as age, marital status, sexual orientation, source of income, military, or veteran status. Examples in Kansas include the City of Manhattan, Kansas, recognizes military status as a protected class, and the City of Lawrence recognizes sexual orientation as well as gender identity as a protected class. So if you own a rental property in one of these cities, you may not discriminate against people in these protected classes, as well as the 7 federally protected groups. HUD-funded housing program protections. The lesbian, gay, bisexual, and transgender rule, or the LGBT rule, clarifies that all otherwise eligible families, regardless of marital status, sexual orientation, or gender identity, will have the opportunity to participate in U.S. HUD-funded housing programs. While this rule is not adding a protected class to the Fair Housing Act, it could apply to protections already in place under the Act, such as the federal protection of sex as a protected class, and therefore a tenant in HUD-funded housing could have a fair housing claim based on this. Again, keep in mind that at this time the LGBT rule only applies to HUD-funded housing programs. Who must comply with the Fair Housing Act? All multifamily homes, to include apartments, duplexes, and condominiums, are covered by the Act. Landlords owning more than 3 single-family rentals must also comply with fair housing law. By the way, the definition of a single-family rental is a house. Who is exempt from the Fair Housing Act? Owners of single-family rental homes are exempt from the Fair Housing Act as long as the landlord has 3 or fewer at any given time and does not use a real estate broker or property management company to obtain renters. Owner-occupied buildings with no more than 4 units are also exempt. This is also known as Mrs. Murphy's exemption. Mrs. Murphy's exemption provides that a home is exempt from the Fair Housing Act if the dwelling has 4 or fewer units and the owner lives in one of those units. This is based upon the hypothetical elderly widow, Mrs. Murphy, who would like to rent part of her home to make extra income and who may desire to specifically pick out her tenants. Housing operated by religious organizations and private clubs that limit occupancy to members is also exempt. Some states and local municipalities may have laws that do not allow the above exemptions. Advertising. Almost everyone must comply with fair housing and advertising. There are 2 exceptions, though. Advertisement for roommates may specify gender if the rental involves shared living space, or if the housing is in a dormitory in an educational institution. So, for instance, if a female is to share living space with a roommate, she may advertise females only may apply. The same applies to a dormitory. If the dormitory houses only males, they may advertise males only. Advertising includes advertisements in newspapers, billboards, bulletin boards, signage, flyers, internet, as well as word of mouth. For an example, you cannot advertise on a billboard or in a newspaper, adults only. In reference to word of mouth advertising, several lawsuits have been filed across America because of discriminatory remarks made by a landlord's employees. For instance, there was a fair housing case involving a maintenance person who was making comments to tenants in an apartment community, saying things like, "Hispanics who cannot speak English should not live here. Only real Americans are allowed." That maintenance person, in essence, was advertising in a discriminatory manner against people based on the protected classes of race, color, and national origin. Examples like this are why it is so important that all your employees receive fair housing training, as well as monitoring. Screening. It is crucial to have a clear written screening policy based on verifiable facts. Screening criteria sets forth the minimum requirements that an individual must meet in order to be able to rent from a landlord. Make sure all employees are aware of your policy. Apply the policy consistently to all applicants. The very first fully qualified applicant should be offered the unit. You can find examples of written screening policies that comply with fair housing law by conducting an internet search, or you can contact HCCI. Landlords may not single out people in a protected class, even for routine questions concerning eligibility for housing. For instance, during the application process, a landlord may ask for financial information and references, but must do so for all applicants. The following requirements and questions are also permissible in a screening policy if addressed to all applicants. Can you afford the rent? There is no hard rule, but most landlords require a tenant to be able to document earning at least 3 times the monthly rent. Will you be able to comply with the rules of tenancy? Will your tenancy pose a direct threat to the health or safety of others? Will you cause damage to others' property? Do you have a criminal history? Are you currently using drugs, or have you ever been convicted of the illegal manufacture or distribution of a controlled substance? Perhaps you've never heard of a reasonable accommodation, or maybe you have, but are not exactly sure what it is. A reasonable accommodation refers to rules, policies, services, or even the physical structure of a rental unit, so that a tenant with a disability can have full use and enjoyment of the rental property, just as a tenant without a disability would have the same benefit. A reasonable accommodation can allow the applicant with a disability to meet essential requirements of tenancy. Applicants and landlords are each responsible for working together to identify the specific accommodation that each accepts as reasonable. There is no obligation to provide an accommodation requested by a person with a disability if to do so would impose an undue financial and administrative burden on the landlord or fundamentally alter the nature of the housing program. Often a reasonable accommodation occurs during the tenancy, such as a request to install grab bars, but it can also occur during the screening process before tenancy even begins. If the housing is subsidized by a state or federal program, then it is the landlord's responsibility to cover any cost associated with such an accommodation. If not, and the housing is market rate, then it is the tenant's responsibility to cover any cost associated with an accommodation. An example of a reasonable accommodation during the application process could be a request for assistance in filling out an application due to a tenant's cognitive disability, which, by the way, doesn't cost a dime. Do not screen based on any disability-related presumptions about the applicant's ability to meet the essential obligations of the lease. For example, you are worried that due to an applicant's mental health issues, he might cause problems in the community. It is also illegal to ask an applicant if they are disabled, and to ask an applicant with a disability, "Can you take care of yourself?" Oftentimes, someone with a disability will have a friend, family member, or care worker come into their rental to cook and clean for them, or bring the rent check to the office on their behalf. As long as the tenant is complying with the terms of the lease and is not in any safety or health jeopardy, then you need not be concerned. If a potential tenant is applying for housing specifically for people with disabilities, a landlord may ask if she qualifies for such a unit, or if a potential tenant is requesting a reasonable accommodation to modify a rule, policy, or practice based on a disability, a landlord may request verification of her need for the requested accommodation, but only if the need is not apparent. If the disability is apparent, do not ask for verification. So, for example, if a tenant is clearly in a wheelchair and is requesting a ground floor unit, do not ask for a verification from a professional that the tenant needs a ground floor unit. If you cannot tell that a tenant has a disability and he or she is making an accommodation request, then you can ask that a professional, usually a doctor, but not always, give you verification of the need for the accommodation. If a tenant wants an accommodation, then the tenant needs to request it. The request is not required by law to be in writing, but it's a good idea. A tenant does not have to use the formal term reasonable accommodation. Instead, they can describe their need, and you as a professional should understand they are requesting an accommodation. For example, if an applicant with a cognitive disability says he or she cannot understand the application, then you know they are asking for a reasonable accommodation that you help them read it or fill it out. They do not actually have to use the term reasonable accommodation. If an applicant with a disability cannot satisfy the requirements of screening because of previous rental history, a landlord must, if requested by the applicant, consider whether any extenuating circumstances related to the disability could be verified to explain and overcome the problematic behavior and permit a reasonable accommodation that will allow the applicant to meet the requirements. Perhaps, for example, a tenant with a mental health disability has a bad tenancy record as a result of failure to take proper medication. If the tenant provides evidence to the landlord that he or she has made arrangements that ensure the tenant will now take the medication, such as daily nurse visits or verifiable written proof from a professional stating the tenant is now in compliance with taking medication, the housing provider may need to waive rules requiring rejection of applicants with bad tenancy records, and therefore the tenant would not be denied tenancy based on this criteria. Discrimination during screening may include inquiring about a tenant's race, color, religion, or other protected characteristic during the application process. Pooling applicants. Pooling applicants refers to receiving many applications in a short period of time, and instead of screening them on a first-come, first-served basis, a landlord picks and chooses applications to screen. Steering. An example of steering is directing applicants with children to a particular building. Setting up different screening standards. Preferences advertised in newspapers, for example, adults only or ideal for one person. Requiring a higher security deposit for tenants using a wheelchair due to damages that may or may not incur. False denials of availability. Refusing to rent to a person who resists the landlord's sexual advances or verbally abusive comments due to an applicant's sexual orientation. Raising rental prices for no other reason than to keep tenants in a protected class out. Strive to treat everyone the same and be consistent. Rejection of rental application. Rejection of a housing applicant is justified if that applicant cannot meet the objective obligations that apply to all tenants. An objective reason to deny an applicant is something that is measurable and verifiable. Examples of reasons for denial include: do they have past evictions? Would a prior landlord rent to them again? Based on your criteria, applied to everyone, can they afford the rent? A landlord should never use a subjective reason for denial, meaning a reason that can't be verified. Example, you have a bad feeling about the applicant because of his race. The Fair Housing Act is enforced by the U.S. Department of Housing and Urban Development and by the U.S. Department of Justice, as well as through private lawsuits filed by individuals. If a case is ever filed against you, you will probably be told ignorance of fair housing law is no excuse. Therefore, training is so important. For more information about training opportunities, you can contact HCCI. The cost of discrimination can be very high. A property manager or landlord could be sued. A property manager could lose his or her job. A subsidized housing agency could lose federal funding, and a landlord and even property manager can be ordered to pay big money damages for a tenant's actual financial losses and attorney's fees and emotional distress. Fair housing can be very complicated. If you'd like more information about fair housing, contact HCCI. You can contact us at 800-234-0217 or 785-234-0217, or visit our website at www.hcci-ks.org. Thank you.